Hey, gun people. All right, this one's probably going to be a long one because it sounds like a bad ruling, but I might have a different opinion of. So somebody sent me. So this is the case of Utah versus Sheriff, whatever, Strieff. And someone sent me this video of this guy. Evidently, I think he's an attorney, Steve Lato. So he kind of talks about this case. Now look, let me preference this. I don't know this dude. I'm not saying he's a bad guy. I'm just telling you, I watched about half of the video, and a few things he said kind of told me that he was probably left-leaning. I don't know if he's a full-blown libertard, but he's definitely left-leaning, like most attorneys are. And at one point he says conservatives believe that police are good and police powers are good, and that is absolutely incorrect. And that sounds like an uninformed liberal who wants to cast bad light on conservatives because they think they're the anti-government party, when in fact they are the pro-government socialist party. But I digress. I don't know this guy. He may be a great dude. I'm not dogging him. I'm not saying go hate him. I'm telling you, I didn't disagree with him, so I said, let me look at a case. Because his opinion, and you can watch the video in case I say it wrong, his opinion is the court says, hey, cops can go out there and stop anybody, and if they got a warrant, no foul. And the ruling used to be, if you stop somebody from fruits of the poisonous tree, and your stop was bad, any fruits you got from that invalid stop, which would have been the poisonous tree, would be suppressed. And then, they would not allow you to use it. And that would be penalty and punishment. And that way, it wouldn't encourage officers to intentionally violate the Constitution and the law. So they had this suppression thing that, you know what, if you cops do something wrong, don't think you're going to get anything out of it because we're going to throw all your evidence out and you're not going to get nothing. So now there's no benefit of doing it wrong except you look bad. Well, now, according to this guy, he thinks the courts have pretty much ruled that you can stop anybody, and if they have a warrant and you find something, it's all good. Now, I don't know if that's true or correct. That doesn't sound reasonable to me, so I wanted to look at the case. So I did. I pulled up the case on this. Oh yay. And they had the oral arguments in 2016. So here's the facts of the case. Let's see here. Facts of the case. Utah detective received anonymous tip about drug sales in a South Lake residence. So he surveyed the area over a short period of time and speculated. Short period of time, I think, was 3 hours. I listened to about 5 minutes of this and went, oh, this will be good. And he speculated that there was drug activity taking place. He saw Edward Joseph Strieff. I'll just call him Sheriff for this, okay? Because it'll make it easier in case I'm butchering his name. Everybody know who I'm talking about. Mr. Sheriff Jr. was leaving the residence and stopped him for questioning. During the stop, he discovered the sheriff had an outstanding warrant and arrested him. During the lawful search of his arrest, he found methamphetamine and a drug pipe. Well, it sounds like when he surveyed it and kind of thought it was a drug house, he was right. Rick, you can't say that. All right, I'm just saying. Let's go. If you go by, all right. During the lawful search, he found methamphetamine. The district court ruled, although Fackrell did not have enough evidence to conduct an investigatory stop, the methamphetamine drug film obtained during the lawful search to arrest justified the admission of the evidence in trial. The Utah Court of Appeals affirmed the decision. Utah Supreme Court reversed the decision. And the Supreme Court, which you're going to find out, said they're right. It is admissible. Now, I don't know what they based it on, but just based on this short thing here, there's a lot of issues. And I don't think the courts ruled that it's okay for cops to do this. There's a big loophole when somebody has a warrant. And I know you people don't want to hear this, but if you have a warrant, I can't enter a third-party house. There was a case called the Stagel case that I can't enter a third party's house with a warrant. And that's so cops don't follow somebody with a warrant. So if I want to search your house and I know your friend has a warrant and I see your friend, I'm not going to arrest him until I follow him. Then when he goes in your house, I'm going to kick your door because he has a warrant. I'm going to go in and search him and find him, and then I get to search you because he's in your house. And the courts went, no, 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 no. You can't do that. If you have somebody with a warrant in a third-party house, you have to go get another warrant to seize that body, and that's called a Stagel warrant. So, and I told you one of my crazy cop stories where that actually happened, and the guy ended up going in, and we got in a bunch of shit over it. But anyway, so when warrants are there, though, the problem with warrants is if you have a warrant, let's say a guy runs in your house, and let's say I kick your door, and I grab this dude. He still has a warrant, and he's still going to jail. That doesn't change. Even though I entered your house illegally, the warrant, I mean, it would be unreasonable for him to go, we have a mass murderer here, and he's going to kill this woman, and we know he's going to kill him, but because you kicked the door, we're going to let him go. So the courts went, that doesn't make sense. We can't be letting violent people go because they arrested the wrong way. If they have an arrest warrant, any way they get in custody is legal. Now, if a cop violates someone else's rights and he kicks doors, then they can face the civil and punitive, which we know probably won't happen. But there are remedies that will hold cops and hopefully stop cops, and they'll violate policy, etc. So that's what this case kind of is touching on, and it should be pretty interesting. And he said Thomas is the most conservative far-right justice. He may be the far-right on here. I don't think he's as far-right as me. But, you know, whatever. Just because Thomas is a conservative and he agreed with this, that doesn't mean because I'm conservative, I'm going to agree with Thomas. I'm going to listen to the facts of the case and try to get you to explain why the courts ruled and why it's not as simple as this guy made it out to be, that, well, now cops, you know, they can just stand on the street and stop everybody and ask them if they got warrants. If they got warrants, then they can search them. And they don't need probable cause, and they don't need reasonable suspicion, and they don't need to have investigators stop. And that's kind of what I thought he said. And I'm not trying to put words, I'm not trying to make this guy out worse. Go watch his video if you think I'm misrepresenting it, or comment and tell me that, hey man, you didn't listen to, and I did not listen to the whole video. I stopped halfway and went, let me look up this case, because I want to hear it. So, let's hear it. And here we go.
We'll hear argument next in case 4.
Mr. Chief Justice, and may it please the Court. Courts typically apply the exclusionary rule to suppress unlawfully seized evidence.
Okay, so that's basically what it was, exclusionary rule. If you get evidence unlawfully, then we're not going to let you use it. Okay? That's what the rule is.
The question here is whether to suppress evidence lawfully seized in a search incident to a warrant arrest, because the arresting officer found the warrant and a stop later judged to be unlawful.
Okay. To understand this, whether or not to suppress evidence lawfully seized in a search incident to arrest. So what that statement means is, if you have a warrant, you are arrestable anytime, anywhere, by any peace officer. And when I arrest you, I can search you. And any evidence you have on you is search incident to arrest, and it's going to be admissible, and it's lawful. So what he's trying to say is that this is what happened here. This guy came out of a drug house. He searched him, found out he had a warrant. When he searched him after he found out he had a warrant, he found drugs. So it should be admissible. And what the other side is saying, yeah, but he shouldn't have stopped him just because he came out of a drug house that he was watching and there was a bunch of people coming into the house, and a reasonable officer with his experience and training would believe that it was a drug house. Therefore, he acted on his experience and training, which was reasonable, but this court happened to read it wasn't. And the big case here that really gets me is you had 4 different courts rule different ways. The first court said good, the second court said good, the third court said not good, the fourth court said good. So it's like even all the judges with all their little pink little pretty robes underneath and their black robes and their great mystical powers on the bench, they can't agree. And everybody wants to look at the cop and go, oh, the cop was wrong. Oh, the cop did it wrong. Oh, the cop was bad. Oh, there's no way the cop was right. You can't get 14 different freaking judges on appeals, Superior Court. You couldn't even get a unanimous decision on the Supreme Court. And people are like, it's the cop's fault. Those damn cops are out there just making up the law. Yeah, okay. Here we go.
Under this court's attenuation analysis, such evidence is admissible when, as here, the predicate stop was not flagrant, but resulted from an objectively reasonable miscalculation.
Okay, objectively reasonable miscalculation. Basically, the cop made a mistake. Basically, the cop says, you know what? I think I have PC. And PC is a fluid kind of thing. When you get into reasonable, articulable, reasonable, whatever you want to call it, RSA, all the different cute acronyms. And when you get into that, those are opinions, and it's based on training and experience of the officer. And no two officers have the exact training and experience. So there is no exact calculation. So when people kind of hear this and they're like, oh, the cops have it all written down, it's a big secret conspiracy, and they all know how. That's not true. Each cop, I got some good probable cause that a lot of officers may not have gotten. And other cops got probable cause that I wouldn't have got because it wasn't my specialty area, and they knew how to articulate, and they knew what to look for, and they knew what indicators led them to their beliefs. So, you know, people who work drugs are better at recognizing drugs. People that work gangs are better at establishing probable cause for drugs. People that work computer crimes, child abduction, child porn, whatever the crime, if you work it all the time, you're going to be able to articulate why you believe what you believe better than somebody who doesn't work that. So, here we go. Sorry.
Extending the exclusionary rule.
Tell me what was objectively reasonable about it?
Well, Your Honor.
Okay, this woman, Sotomayor, is just a total left-wing, I'm a woman, I'm a victim, and I'm Hispanic and I'm a victim. And in her opinion, she wrote something about, according to the other guy, that black and brown people have to have the conversation with their kids about, remember, if the cops stop you, keep your hands and don't. That's not just black. That's any damn common sense parent would tell their kids that. But she wants to make it about race and the poor black and brown. I get so tired of these left wings. They can never just discuss something without making somebody the poor victim, and it's different. All right, sorry. I'll go on.
Tell me what was objectively reasonable about it?
Well, Your Honor.
I mean, the police officer admits that the person he saw coming out of the house in question wasn't doing anything. He didn't know that he lived there. He didn't know what he had done, if anything. He didn't even really know that there was drug dealing going on in the house. He was trying to figure that out. So what was objectively reasonable?
Well, Judge, miss having the talk with the black and brown kids that all parents have to have. Maybe you should have a talk from the cops and figure out that when you have a house and somebody calls it in on a tip and says, I think they're drilling drugs because people go in there and leave really quick, and I think they're just making transactions. And then you get somebody with more than 2 brain cells on the Supreme Court who can figure out that, hey, maybe if there's a house that the neighbors are complaining this has happened, and then when a cop with training and experience in drugs watches the house for 3 hours and figures out, you know what? People are coming here and leaving, just like the tipster said. That corroborates the tip. Therefore, I'm kind of in agreement with him. It's not normal for people to visit a house for 10 to 15 seconds and walk in and then walk out and leave. That's not normal for most normal people with 2 brain cells. But Ms. Sotomayor, Supreme Court female, quota hire, oh, that's not objectively reasonable. All right, I digress. Go ahead.
About stopping this man.
Justice Sotomayor, we've admitted that this was a miscalculation, but it was a close call. If the officer here had stopped the first person coming out of the house after receiving...
it was a close call. I know I'm going to get all the people who are saying I'm carrying a flag for the cops here. A lot of probable cause and stops and searches are close calls when they have to be made on the fly in uncertain and continuously evolving situations out there. This wasn't an emergency, but it's still a call that government has given cops the ability to make. If they don't like it, then take it away. Not only did they not take it away in this case, they gave cops more power. And I'm not saying I agree with it, because on its face, it sounds like it's BS. But we'll see.
Tip, that would have been objectively unreasonable under this court's case and decision in Alabama versus White. But this person wasn't the first person he saw come out of the house. He'd received the anonymous tip and then had proceeded to corroborate it through 3 hours of surveillance and observation over the course of
Call me silly. That sounds reasonable to me.
And all the traffic he saw during those 3 hours was the same short stay traffic that was reported in the tip. Based on his training and experience, that activity was consistent with drug sales.
Notice how she doesn't let him articulate why he did it to answer her question. She just wants to push her agenda.
To see whether this was also a short stay visitor.
I think you would have.
I don't see how this is any different than stopping the first person you see.
It's hugely different in stopping a first person. You have a pattern of behavior. There is a term when you're working with criminals, it's called scheme and design. And most people who do certain crimes have a certain pattern that you can predict what their crime and what you're going to find. Just like you would predict that somebody selling drugs would keep a log of who pays him and who owes him and how much he sold and how much they bought. And they keep that. Just like you would predict that a bookie is keeping down how much money somebody bet and how much they won and how much he paid them and how much he didn't pay because they lost. You can predict that if you have more than 2 brain cells and not on the Supreme Court, that is a pattern. And when you have patterns, predictable patterns that you can reasonably predict with certainty, then it becomes reasonable. And that's how you get probable cause.
As we've admitted, I think if he had seen it and it were short stay, I think we may well be to reasonable suspicion. And I think that's why the prosecutor here conceded that it wasn't. But it was a close call based on everything he had seen to that point. And in these circumstances, we think that's why where the predicate conduct was a result of misconduct that was not.
What's going to stop police officers if we announce your rule? And your rule seems to be, once we have your name, if there's a warrant out on you, that's an attenuating circumstance under every circumstance.
That's correct. That is the law right now. The only thing that's different here is if I stop you unlawfully, then there's an issue on why I violated your Fourth Amendment rights and why I stopped you unlawfully, and is there a civil rights issue, and am I doing something illegal? Now, the courts have already ruled that I can stop you, I can see you down the road and go, you know what? I just don't like the way you look. It's not about color. I don't like the way you comb your hair. I don't like that you have a freaking Beto or Hillary or Obama sticker on your car. The courts have ruled I can stop you even if I base a stop that I don't like you for your sticker, as long as I have a lawful violation. So I don't like your sticker. I'm behind you. You fail to give a turn signal. I may not stop other people for a turn signal, but I'm going to stop you because I don't like your sticker. The courts have ruled that is okay 100%. So now she's crying. What's going to stop? Well, you are, you're on the Supreme Court. You idiots are supposed to stop it.
What stops us from becoming a police state and just having the police stand on the corner down here and stop every person, ask them for identification, put it through, and if a warrant comes up.
Happens now every day. If I stop you because somebody points at you and go, hey, he was involved in domestic violence. I go, dude, were you involved in it? No. You got any ID? Yeah, you give me ID, I run, you got a warrant. I can search you. Sorry. I mean, that's just the way it is.
I think, Justice Sotomayor, I think there are 2 answers to that question. First, I think that our rule, an officer can never count under our rule on finding a warrant. So there is no incentive for him to make that stop. If there's no warrant and the stop is lawful.
If you have a town like
Oh my God, I can't believe she said this in open court on the record. Listen to this statement. She's saying a town like Ferguson, where everybody's black and there's always riots, where 80% of the residents have minor traffic warrants. Well, that's kind of a stereotype. Shit, that sounds like probable cause. That almost sounds like predictable behavior. Exactly what cops use to profile. Oh, Rick, you can't do that. She just did it. Miss, give your talk to the black and brown children and nobody else should get the talk. Whatever.
If you have a town like Ferguson where 80% of the residents have minor traffic warrants out, there may be a very good incentive for just standing on the street corner in Ferguson and asking every citizen, give me your ID.
Don't forget, the Supreme Court ruled that DUI stops where they herd traffic, they can stop you for no reason and ask for your ID. And now she's saying that you shouldn't be able to do that. But they ruled that you could do it. And DUI checkpoints are not illegal. And they are constitutional, and you have no rights. And now she's going to act like suddenly she doesn't believe that. Oh, hypocritical.
See your name, and let me hope, because I have an 80% chance that you're going to have a warrant.
Well, I understand, Your Honor, and that's the second part of my answer is that officers can't count. Under our rule, a warrant by itself is not sufficient. There still must be a separate inquiry into whether the predicate stop was flagrant, and an officer can't count in any particular stop on a judge later concluding that the stop.
But I wanted to kind of go over that because, so
there still must
the
be
separate inquiry into the stop is flagrant. Remember they said this was a close call. So flagrant means that, you know what, I'm driving through a town, damn, there's a black dude in that house and I don't like black people. I'm going to stop him and ID him. That's flagrant. If that's the reason I stop him, then that's flagrant. I have no probable cause. I'm picking him up because of color. You can't do that. However, if I'm driving down a high crime area and this house has been busted 3 times and there's doors with big old holes from where the last raid warrant knocked down the doors, and it's a high drug area, and I observe a dude that I've arrested for drugs twice before go in this house, and when he walks out, he sees me and runs. According to her, I shouldn't be singling him out. Do you see the difference between totality of circumstances to where they're trying to pin this down to, oh, we're going to take each individual circumstance and tell you how it's bad? Pay attention, people. They'll trick you.
Inquiry into whether the predicate stop was flagrant, and an officer can't count in any particular stop on a judge later concluding that the stop.
But I assume, Mr. Green, that there are a variety of circumstances in which police officers would really like to talk to somebody and really like to search them, but don't have reasonable suspicion. And I think that the question that Justice Sotomayor is asking is, if you're policing a community where there's some significant percentage of people who have arrest warrants out on
maybe those people should take care of their warrants. Maybe the court should arrest people or keep people in jail when they skip out on their warrant. Maybe we should stop doing, racial politics and making this an experiment on how everything is bad when people commit crimes and they get warrants. Maybe we should stop that. No, Rick. Pay attention. This is about, the poor people with warrants getting picked on because they have warrants. Jesus Christ.
It really does increase your incentive to make that stop on the chance that there will be a warrant that will allow you to search and admit.
If you had been paying attention earlier, he said there has to be a 2-pronged test, and you have to see if it's flagrant that the officer is making flagrant stops and doing this with the intent just to find warrants. And that's pretty easy to figure out.
You gain in that search.
Justice Kagan, I don't think so. I think, again, if the inquiry turns, as it does, on not only finding a warrant, but then a determination of whether the stop was flagrant, the officer has no guarantee before he makes the stop that a judge will later conclude.
Well, but this is an officer who, you say this is a close call. So let's say that there are close calls.
Yeah, let's say there are close calls. We have the Supreme Court that can't agree. We have the appeals court that can't agree. We have the 2 lower courts that disagreed. And now, okay, well, let's just say we might have close calls. They're all freaking close calls because it's a damn gauntlet on who you're going to get for a Supreme Court that believes you or doesn't, or that doesn't like the cops or doesn't like it or think the color of the person. And if the person's white, well, then it's okay. And if he's not white, then it must have been bad. I mean, it's always a damn crapshoot.
You have reasonable suspicion, or you think you maybe do if you find a good judge out there. But
it's already illegal to go judge shopping. When you hear people go, oh, if you can find a good job, that's illegal. You are not supposed to do that. Most courts have put judges on call, and you have to go to the on-call judge. You can't go to the judge of your choice. We used to have phone numbers of all the judges, and you just call whatever judge you wanted. And then when they started saying, you know what, we got some people who are judge shopping, and they have a relationship, so they always go this judge, and he's viewed all his warrants. So they go, you know what, we're going to stop that. And you can't go judge shopping. If you do go judge shopping, you're going to get charged for not telling the next judge, because some people used to go, if this judge turns me down, I'm going to take it to a judge I like, and then he'll agree with it. And when that judge did it, The other judge goes, dude, I turned that down for this. And he goes, oh, he didn't tell me he talked to you. Well, that's where the cops messed up, because we're required, and we sign under penalty of perjury, and we swear to that warrant that everything in that warrant that the judge needs to know is in there, and we can't withhold that we took it to another judge and they said no. Unlike they do on the freaking FISA warrants with no checks and balances. But I digress.
There's a reason why you want to talk. So this is not a flagrant violation. This is not a dragnet search or something like that. But it does change your incentives quite dramatically, it seems to me, if you're policing a community where there is some significant percentage of people who have
And what communities would those be, Your Honor? Because I'm confused. I was always taught that everybody was equal, and we didn't have bad neighborhoods. We didn't have communities where everybody had a warrant. What exactly are you talking about, Judge? I'm confused, because I've been living in liberal la-la land where everything is equal and, only crazy people go out there picking on certain people. Whatever.
Well, Justice Kagan, I think with respect, doesn't officers know that the only surefire way, the incentive is always to comply with the Fourth Amendment. That's the only way they can be sure that the evidence they are gathering is later used in a prosecution.
That's the only way they can be absolutely sure. But here, there's some chance that they're going to find the arrest warrant, and then they're going to be able to admit the evidence that they're going to get. Whereas before, there was none.
I agree with that. I think you should lose the evidence. You don't lose the arrest because he's already got the arrest warrant's already been reviewed. But any evidence you get, since you stopped him illegally, I think you ought to lose the evidence. Now, I know Clarence Thomas ruled the other way on this, and he's a conservative. And it don't make him right, because I'm right. And I think on this case, that is a better way to hold government accountable. They want to make it a police thing. I want to make it a government thing. And unfortunately, all these little robes are government.
And that some chance is not like a once-in-a-blue moon kind of chance. In these very heavily policed areas, I was staggered by the number of arrest warrants that are out.
That's because you live in freaking la-la land and you ain't got a clue, and you're up there ruling on the public that you have no freaking clue, but you can say there's bad areas where a majority of the people have warrants, and you won't be called a mean racist and a white male because, well, whatever.
So it's, a significant possibility that you're going to find an arrest warrant and be able to admit whatever drugs or guns or whatever it is you find.
Well, I think, Your Honor, in those circumstances, that's where the flagrancy inquiry actually does the work of deterrence. Because as this Court has explained, to be appropriate, suppression must yield appreciable deterrence. There may be some additional marginal deterrence that suppressing everything following an event like this would yield, but that's never been enough under this Court's precedents.
Don't you think it's enough of a deterrent to say to a police officer in this situation, you should have reasonable suspicion. You know the Fourth Amendment requires it. So before you do an intrusive act demanding identification, you do what you're permitted to do, which is just to ask the person whether they'll talk to you. Don't you think that would improve the relationship between the public and the police?
That sounds like a great idea. Too bad you idiots, who I think ruled unanimously that DUI checkpoints stopping people and demanding registration and driver's license for no probable cause was legal. But here you're saying, well, never mind.
Wouldn't that be the appropriate encouragement we would give if we don't let police do these things in questionable situations?
Well, Your Honor, I think that's what the existing rule and the exclusionary rule itself does. It encourages officers to comport with the Fourth Amendment. This applies only in the limited.
We're discouraging them now from doing that. We're saying if you have questionable probable cause, go ahead and do it, because we're not going to make you take that extra step of just merely stopping someone and saying, will you talk to me, please?
No, I don't think so, Your Honor. I think, again, because there are two predicate steps that must happen before this exception would apply. And the officer before the stop can't count on either one. That's why when we are talking about conduct here that is admittedly a violation of the Fourth Amendment, but low culpability, that's where the additional marginal deterrence that would come from suppression doesn't do its work. And with respect to the particular type of intervening circumstance here, this is a compelling intervening circumstance of the type that this Court identified in its holding in Johnson versus Louisiana.
Mr. Green, you make a point that a person's name is not suppressible, and evidence derived from just knowing the name is not suppressible. If you're right about that, then the police could stop anyone and say,
she's just talking because the other two females talk. She don't even know what she's saying. She's just repeating kind of what they said. Somebody feed her some more oatmeal so she'll be quiet. Get her a little bib.
whether I have reasonable suspicion or not, I want to know your name. And that's not suppressible. Then does the warrant check, which you say is an intervening circumstance.
Remember,
So
these
it
guys
seems
only
that
have so much time, so that you notice the ones that disagree are eating up his time so he can't make points. But it doesn't matter. They've all made up their decision before they even get out here and listen to this. None of these guys change their mind because of what people say.
argument is arming the police with asking every person, what is your name, and doing the warrant check.
Well, Your Honor, it is, of course, that's one of the purposes of a Terry stop, of an investigatory stop, is to try to find a person's name.
I thought you needed reasonable suspicion.
That's correct. That's
but
correct.
This is a case where you're telling us reasonable suspicion or not, the name, a person's name, is not suppressible.
That's right, Your Honor. But it is admittedly the but-for link between the initial predicate unlawful stop and the later discovery of the warrant and the arrest on the warrant, which is the intervening circumstance. That's why, Your Honor, we think this falls comfortably within this Court's prior attenuation jurisprudence.
And here's the other problem that you get into this, is the flip side that nobody wants to bring up is if you don't encourage cops to try and find these communities with 80% of the people having warrants, if you don't encourage them to try and get these people with warrants into jail, then you'll have 90% with warrant. Then you'll have 100%. Then warrants won't mean anything. Then cops will just be hanging out at the donut shop, and they won't care if you have a warrant or not, because they just won't talk to anybody, because it may be close, and they may get in trouble. And so there's always a flip side of this, and again, I already told you, I think they ought to suppress any evidence they get. But I don't think they ought to suppress the arrest, because the guy's arrestable. And I mean, but we'll see.
So
Just
what
like
is
the-
an intervening circumstance in your view? What is your test for what it is?
Your Honor, we think under it flows naturally from this Court's teaching in Wong Sung, that is, it's any means sufficiently distinguishable from a predicate unlawful act such that suppressing evidence seized after it would not yield appreciable deterrence. And this Court's cases have.
Your view is that we should look at the question of whether something is an intervening circumstance through the deterrence lens. That makes a lot of sense. We look at everything through a deterrence lens with respect to the exclusionary rule. And that, what we're supposed to say is does this appreciably increase deterrence or not? Is that correct?
That's the inquiry, Your Honor, yes.
And so I guess then I'm back to my question. In a world in which finding somebody with an outstanding arrest warrant was an extremely low probability, you would be right. In a world in which it was an extremely high probability, you would be wrong. Then it seems like, where is this on the spectrum? What do we know about that? It sure seems, again, I will come back to this. I was surprised beyond measure by how many people have arrest warrants outstanding, and particularly in the kind of areas in which these stops typically tend to take place.
I can't believe she said that. She's trying to say that there's bad neighborhoods out there with bad people with warrants, and the cops are actually stopping people in these bad places where they have 80% of the people have warrants. Ooh, those mean cops. I'm surprised. I'm shocked. Have you noticed the 3 women are the only ones that's been running their mouth on this guy and he can't get his case made? All right, that's just a tip.
So that, it seems to me, is a pretty strong argument for why this will increase deterrence.
Well, Your Honor, again, I think, Justice Kagan, the answer to that is the inquiry here in attenuation is not just is there an intervening circumstance. Under this Court's prior cases, there still must be something else. And we think that something else, following from this Court's teaching in Brown, is a flagrancy inquiry. What level of culpability does this conduct display?
Do you think that something else includes a subjective component, whether there was a purpose to see if there was a warrant?
We don't, Your Honor. We think that inquiry is inconsistent with the way this Court's Fourth Amendment jurisprudence has evolved. It's an objection.
So isn't flagrancy?
It is true that would be a step maybe beyond our cases. On the other hand, if the inquiry is one of flagrancy, then maybe that's necessary. And it may be particularly necessary here because under the line of questioning that Justice Kagan just concluded with you, it would seem odd for this Court to say the higher crime, the more it's a high crime area, the less basis you have to stop.
I think he just called her a freaking idiot, but he didn't want to say it.
So it seems to me that the subjective purpose component might serve an important purpose here, so that a police officer can't just say, I'm going to see if there's a warrant for this fellow. That's the reason I'm going to stop. That seems to me quite wrong.
Well, Justice Kennedy, I think the answer to that question is that in the cases upon which respondent relies, citing the subjective purpose requirement, those have all been cases involving arrests without probable cause. And in those circumstances, the factors and the facts that we think this Court discussed in those cases go to show the objective unreasonableness of those particular actions. We think it's different in the context of a Terry stop, where this Court has repeatedly said courts can make the stop in order to investigate, in order to confirm or dispel suspicion. And that's particularly so, Your Honor, where with relation to the two-part test that we think is appropriate here, where the intervening circumstance is a pre-existing warrant based on probable cause arising from facts completely unrelated to the stop. That type of intervening circumstance matches up precisely with what this Court found in Johnson versus Louisiana, where the intervening circumstance there was a commitment.
This is a non sequitur. When you talk about an intervening circumstance, as we've looked at it in the case law, it's always been something different than the actual stop. Another police officer comes by and says, oh, I've been searching for that guy. I know he has, I have an arrest warrant for him. A witness walks by on another crime and says, he just robbed me down the block. Those are intervening circumstances because they are something outside of the stop. But this location of evidence was a direct product of the stop.
Well,
it would never have happened except for the stop.
Your Honor, we agree that there's but-for cause here, but with respect, there was actually something else that happened here. That was that prior finding of probable cause by a neutral and detached magistrate on a crime completely unrelated to the facts at issue.
He's talking about the warrant was issued by a judge after they reviewed a different probable cause. He's not talking about this one.
Stop. So in that sense, it does resemble.
You know something? Finding the baggie of cocaine gives the officer probable cause to arrest. But we don't let that cocaine come into evidence merely because it was a ground for the arrest. We look at how the evidence was secured before deciding whether it's suppressible or not. And I don't see how this is any different than not letting someone be arrested or suppressing DNA evidence, fingerprint evidence that leads to other crimes. We've suppressed those things because they've been the product of an illegal stop.
And Justice Sotomayor, we agree with you that if an officer had found a bag of cocaine during an unlawful stop, that's the precise situation where the exclusionary rule would usually apply. What's different here is that the search in which the drugs and the other evidence was found occurred while the suspect was in lawful custody. Respondent has admitted that the arrest warrant was lawful, and the arrest was therefore lawful. And under this Court's decision in Robinson, once the arrest is lawful, the search incident to it is lawful, and all the evidence gathered in any search is lawfully seized.
Once I place you under arrest, if it's a lawful arrest and I search you incident arrest, the search was lawful. But it becomes a Pandora's box when, well, how did you find out I had a warrant? Well, maybe it wasn't done the right way and you found out I had a warrant. Should it be King's X, ollie ollie oxen free, everybody gets to come home free and we scratch everything because you had a warrant? I'm okay with that because we're dealing with people who have warrants. We're dealing with criminals. You don't get warrants unless you're criminals. Okay? Rick, everybody's innocent. Anybody that's got a warrant has been convicted, has a rap sheet. If you find somebody that's got a warrant and they've never been arrested before, then I'll talk to you. But until you've been out on the streets and you see that everybody you arrest has a 14-page rap sheet, I don't want to hear this about, well, you know, he really wasn't convicted and the warrant really wasn't good. I mean, that's just living in freaking lollipop land with the liberals.
Mr. Green, you make a statement in reply brief that says the Fourth Amendment does not require officers to have reasonable suspicion before they check for warrants. If you mean that, then any officer can say, what's your name? I'll check you for a warrant.
An officer could do that, Your Honor. That's certainly right. But what happened here is that, of course, that request came during the course of a stop that we've conceded was not supported by reasonable suspicion. And so the question is, what happens?
But you say they didn't need reasonable suspicion.
Where's my oatmeal? Somebody changed the channel. The hell? Only the freaking Supreme Court justice can't even talk about reasonable suspicion.
The officer doesn't have to have reasonable suspicion. It can grab you, what's your name, and check for warrants. And that doesn't violate the Fourth Amendment.
Well, Justice Ginsburg, they don't have to have reasonable suspicion to check for warrants, but that's different from making the initial stop, where, of course, they do need reasonable suspicion.
Okay, let me tell you what a cop can do. I can see you driving down the road. I can run your license plate. I don't need any reason. I can just run your license plate, see if the car is stolen, see if it's registered, see if it's on the right car. It's in a public place. I view it in a public place. I'm where I'm authorized to be. I can run your plate. Now, when a plate comes back to Billy Joe Bob, and I look at you, and you look like your name could be Billy Joe Bob, and you look about 25 years old, I can tell dispatch, run Billy Joe Bob about 25 years of age and see if you get any hits. And when she runs you, it goes, yeah, he comes back as a registered owner of the car that you're behind. Really? Well, run Billy Joe Bob with his date of birth and see if he has any warrants. And then the warrant come back and says, Billy Joe Bob has a warrant. Guess what? I can pull you over and arrest you for that warrant. And everything I did was legal. How is that any different? The difference is I didn't impose government power on you while I was doing this. I didn't stop your flow of traffic. When I stop you just to run you, I think we're getting into issues. Then you get into a police state. And I don't think the court is saying you can do that now. There still has to be that reasonable test afterwards.
I'd like to reserve the remainder of my time.
Thank you, counsel.
Mr. Chief Justice, and may it please the Court, I'd like to start with the concern that Justice Sotomayor and Justice Kagan have both raised about these communities.
Okay, so you already know this guy is addressing the three friendly court members that's been arguing with the guy the whole time. Now let's see how often they kind of challenge this guy.
Of outstanding warrants. As a preface, there's a lot of communities where there's not a lot of outstanding warrants, and the rule that respondent wants you to establish would exclude evidence of serious guilt on serious offenses nationwide, but focusing on communities like Ferguson with a lot of outstanding warrants.
Sorry, I don't understand why. If there's an arrest warrant for someone, for whatever reason, you can arrest them. What you can't do is stop them illegally to effect an arrest.
If you have an arrest warrant and I'm stopping you to arrest you, it is not illegal. The fact is, if I don't know you have an arrest warrant and I'm just stopping you to see if you have a warrant, then we get into why did I target you? And, you know, I used to tell people when I was a cop, I always carried these flyers with all the people that committed the robberies and auto thefts and who they're looking for. And we'd have all these little handsheets, and I would keep those in my car. And I would go over them when I'm parked or when I'm writing a report or waiting for somebody or on a stakeout, and I would get those things in there. And when I saw somebody that looked like one of those, I could stop them based on that flyer if they looked like the person and go, you know what? A person who looks just like you has a felony arrest warrant. Do you have any ID? And I could ID that person. And if they had a warrant, I'd arrest them. And it was a lawful stop. And it's reasonable. But, you know, they don't want to discuss things on real life. They want to discuss in fairyland where they live in their robes.
It's not as if they're going to get away from whatever the underlying crime was. There's an arrest warrant. They're going to go back and serve their time on whatever circumstance existed warranting that arrest, why are they getting away with anything?
What's being excluded is evidence of the crime that was found.
Of another crime that the police would never have found, but we do that.
Well, they might have found it during a separate valid execution of the warrant without a preceding Terry stop. But the evidence found on a person, for example, a firearm, can be very serious crimes that are also of significant danger to these communities.
But that's true of all evidence we suppress. Now you're attacking our suppression jurisprudence. We understand there's a cost to suppressing evidence, but we believe, as we've been taught by our precedents, that there is value in ensuring that the Fourth Amendment is respected.
Except when we want to stop you for DUI checkpoints and when we want to allow dogs to walk around your car and smell and give cops instant probable cause from a dog responding when, a dog can't take a witness stand, a dog isn't a witness, you can't question the dog on his response. But yet we're going to say he overrides the Fourth Amendment protections. And DUI stops override the Fourth Amendment protection. And when you go into a courtroom or you go on a plane, you have no Fourth Amendment protections. You can be searched, prodded, and poked. We don't mind on those, but for some reason, they really got a problem with the Fourth Amendment on this case.
Of course, and the overarching inquiry always is weighing those very serious costs of excluding evidence of guilt against the deterrent value that you would get.
So what's our rule now? Now you don't need reasonable suspicion to stop someone. You only need questionable reasonable suspicion to stop someone.
Well,
and now, so we've now lessened the standard, the Terry stop standard, which is fairly intrusive.
I don't think they've lessened anything. The cop still has to justify why he stopped. And if he doesn't have some sort of explanation, and even if his explanation is weak, it can be thrown out. So it's not like King's X. Every time now it's going to be get the evidence. Every time it's going to be looked at, was the cop flagrant or was he not flagrant? And again, I don't agree with this. I think it's easier to say, you know what, you lose everything. The flip side is if you stop a guy for a warrant and he's got a misdemeanor warrant and he's carrying a freaking knife that was used to kill 4 women and a serial killer, and we find bodies based on that knife with DNA, these justices are like, oh, no. It's a misdemeanor warrant, and he had rights, and we should just let this murderer go. And the dead bodies, oh, well, too bad. See, there's no common sense when it comes to this. Oh, shit, I hit the wrong damn button. What the hell did I do?
I suspect, and I don't know whose brief it was, yours or your or petitioners, but someone said the public will stop this if they don't like police stopping you with no cause. I think the public may end up stopping things, but in a way the police are not going to like.
Well, Justice Sotomayor, we're not talking about all Terry cases. We're talking about a class of Terry cases where an intervening event of huge legal significance occurs. It turns out that a neutral magistrate had already found a probable cause to arrest this person. So we're certainly not talking about lowering the Terry standard in all cases.
But you're going to talk about the statistics, Mr. Bash. Could you do that? And does the United States know the percentage of residents of the United States who have outstanding warrants?
We don't know globally. In the reply brief of the petitioner in this case, he cited a study submitted to the Department of Justice in 2004 that looked at 2 counties. I don't pretend they're representative, but it's a county in Minnesota and Maryland. And it was an extremely low number of warrants per person. And, of course, using that number would take the assumption that every warrant is for a different person, which is probably not true. And it would assume that the population reflects the total number of people who could be subject to warrants. But, of course, people pass through, people come in and out. So it's probably extremely low. I do take Justice Kagan's point, though, that there are some communities where the warrants are high. I want to focus on
and what?
I'm kind of confused. I'm trying to keep up. What communities where they have those high warrant statistics? Rick, you can't ask that question. Okay.
What should we be concerned about there? What would prevent the problem in communities like
communities
that?
Like that?
It's important to know that
like that. Communities like that. Somebody help me out here.
Respondent's rule does nothing to solve the problem that the Department of Justice in its March 2015 report on Ferguson identified. What was going on in Ferguson is that the municipal court, in conjunction with the police, were using arrest warrants as a revenue-raising measure. They were issuing warrants for very minor offenses and failure to appear, and then police officers on the scene had the incentive to arrest people to bring them in to pay the fine. Respondent's rule does nothing to solve that, because everybody agrees the arrest is lawful. The Department of Justice did not find, even in a community with a significant number of arrest warrants as Ferguson, that officers had an incentive to search and that they were acting on an incentive to search people incident. The incentive was to arrest and pay the fine.
But I guess I take the point, Mr. Bash, but I guess I just don't understand. Of course, this is a nationwide rule that we would be setting. But most Terry stops do not happen in most neighborhoods. Most Terry stops happen in very high-crime neighborhoods.
Your Honor? Because you're using these terms like them and those type of neighborhoods. And where are they at? Can you tell me where they're located? Liberal, left-wing run sanctuary cities. We call that a clue.
Appropriately. But where people have lots of arrest warrants. And you might be right about the specific Ferguson case, but I still have my question, which is, why doesn't that dramatically change the incentives for police officers in deciding whether to search somebody? If you know that there's a significant possibility that somebody you stop is going to have an arrest warrant, that's another reason to stop them.
Let me tell you why cops wouldn't do that. It's a pain in the butt. Most cops don't give a shit about arrest warrants. We don't care about that. We can search them after we arrest them, because if we stop them, we have to arrest them. Then we have to do paperwork. And most cops are lazy. They're government employees. They're quota hires. They're in a union. They want to do as least as possible. The Supreme Court, the same Supreme Court that seems so concerned about these cops doing all this work, just ruled that there's no duty to act by police officers. And now all of a sudden they think, because of this rule, cops are suddenly going to throw their donuts away and rush out and ID everybody just to get an arrest warrant. Really? You don't have a freaking clue what cops are thinking.
Justice Kagan, I don't think the empirics show that the numbers are so great that even in high-crime neighborhoods, at least outside of the Ferguson circumstance where you have this odd revenue-raising scheme, that the chance of both finding a warrant and then finding contraband in the search incident to arrest is so high that it's incentivizing officers to conduct illegal stops solely for the purpose of finding a warrant.
That was my point about the importance or the likely importance of purpose in this analysis.
I was actually just going to turn to that, Justice Kennedy. I think when this Court has mentioned flagrancy in cases, not only those cases listing the Brown factors, but also cases like Leon and Herring, what it has been concerned about in part is the notion that once you establish an attenuation principle, what I would say is a common sense principle here, that generally an arrest warrant should be a superseding cause of the discovery of the evidence, you might have an officer exploiting that rule precisely in order to get evidence in searches incident to arrests. So I think the way you could think about flagrancy is, did this officer have the purpose, and it could either be a purpose objectively understood from all of the facts, or it could be a subjective purpose, to exploit this attenuation exception precisely in order to search incident to arrest. I don't think the facts here remotely get there. I don't really think even Respondent has argued that. This was a legitimate investigation. The officer may have made a mistake about the quantum of suspicion necessary. But if you had a case where an officer truly, either objectively or subjectively, is going out just pulling random people over because he now knows about this attenuation rule established in this case, I think that's the sort of flagrancy consideration in cases like Leon and Herring this Court has left as a safety valve.
Which is exactly the same thing with every law and every police power. Any cop could be out there stopping people illegally. I always hear, cops are always planting evidence. Cops are just making up stuff. Cops are... You could be right. There may be, but it's not so prevalent that, you know, I mean, even with all the YouTubes and all the cops that I'm cracking on doing some stuff, it's still not the majority, and it's not an overwhelming issue. And anytime you give police power, there is the chance that some idiot's going to abuse it. But fortunately, the idiot that abuses it has to get his idiot sergeant to go along with it. He has to get his chief and captain. He has to get the DA, and he has to get the judge to go along with it. And trying to get all those people even agree if it's freaking raining out is damn near impossible. So there's checks and balances. So, I mean, it's hard to say, you know, there's a catch-all. Nothing's perfect in the law, and it's all fluid and constantly changing as crooks in the community changes to adapt to it.
Does that mean that we're going to have to, in every single case, explore the officer's subjective motivations? Because that sounds like the kind of inquiry that we've tried to stay away from in the past.
Justice Kagan, Justice Kennedy suggested subjective motivations, and I think that has some support in the earlier attenuation cases like Brown and Dunaway and Taylor, where it really did seem to be that the court was inquiring about purpose. And it also has some support in doctrines like inevitable discovery, which does ask, what were you going to do in fact?
Let me talk about inevitable discovery.
In more recent cases, the court has.
That's a pretty fair concept. The courts have ruled that if you find something illegally, they're not going to suppress it if you can prove that it would have been discovered later. So if I beat a guy and he tells me that the gun that he used to kill the woman is hidden in a locker in his basement, because I beat him, that would fall under exclusionary rule. I got that statement because I beat him, it was unlawful, and I lose that evidence. However, the Supreme Court, with all their robes, got together and said, you know what? If you would have found that anyway, because anytime you arrest somebody for attempted murder, you're going to do, it's standard procedure, to do a search warrant and search their house. And if you did a search warrant and found that gun, you would have found it in the locker where he told you it was at. So you would have got it anyway, therefore we're going to let that gun in. So all you have to do is prove inevitable discovery. It would have been discovered somehow. Okay? If it's in the gutter, I can prove inevitable discovery by saying, you know what? The next rain would have probably washed it and it would have floated. And somebody would buy that and go, oh, okay, inevitable discovery, we'll let it in. They got idiots out there. They got guns that float? Yeah, they do, you freaking idiot.
Has moved towards an objective test. So I think the way the court could formulate the flagrancy safety valve in this case is to say, does this stop appear objectively designed to exploit the ability to search incident to arrest on a warrant? And it could look at all the circumstances. It could look at the fact that this wasn't incident to any legitimate investigation. It could look to the fact that the officer pulled over several people and searched them for warrants in the same incident. I think it could have that safety valve, which would have the effect of preserving cases like this one, where an officer is acting in good faith and someone is found with very serious evidence on them of drug trafficking or a firearm, and it would make
we've gotten to the point where we no longer have reasonable suspicion at all, because you keep defending this stop. And I keep going back to he has an anonymous call. He does see a certain number of short-stay visits, but he stops someone who he doesn't know has been a short-stay visit, has not seen there before, knows nothing about this person, and is doing a complete intrusive stop, not just a, hey, will you talk to me stop, but a formal investigatory stop on nothing else.
Justice Sotomayor, respectfully, I think this was a close case, and I'll just lay out why. Maybe you'll disagree with that. This is an officer with 18 years of experience and several years or a couple years in drug crimes. Got an anonymous tip that this was a drug house, observed it intermittently for 3 hours, and saw short-term traffic that was consistent in his experience and expertise with drug activity. And then someone walked out of the house. That person could have been one of two people. He could have been a short-term visitor, in which case I think most people would agree that there'd be cause to stop, or he could be a long-term resident of that house. And there's not too many houses that are involved in a ongoing drug trafficking or drug sales that a long-term resident of that house wouldn't know about. I mean, this wasn't a pizza delivery man.
Yeah,
this was
it's a given that there was no reasonable suspicion. And you can argue whether it was, but for our purposes, there was no.
Who just woke her up?
Reasonable.
Somebody let her go back to sleep. Give her a blanket. She needs her blankie.
Suspicion.
As the case comes to the court, that is correct, Justice Ginsburg. My only point was this isn't the example, in my mind, of the safety valve flagrancy situation that I was discussing with Justice Kagan and Justice Kennedy.
Mr. Bass, the reason that this case comes to us is because the Utah Supreme Court says, this is three things and flagrant. This is all very confusing, and courts are coming out all over the lot, so we want to come up with a simpler test. Do you have are you saying Utah was wrong, the three-prong test that we have now is fine? Would you change in any respect how we look at these attenuation?
Well, I don't think the three-prong way is a bad way to look at it. The cases have actually used the three prongs to determine whether a defendant's confession is the product of free will. Mr. Chief Justice, can I we think it's a fine way to think about this case in the sense of the court could hold superseding legal authority by a neutral magistrate is an intervening event of significance for the attenuation analysis, and suppression would be appropriate only if the stop was flagrant, either objectively or subjectively understood.
Thank you, counsel. Ms. Watt?
Mr. Chief Justice, and may it please the Court, Utah's proposed rule would open the door to abuse. It would create a powerful incentive for police officers to detain citizens without concern for the Fourth Amendment, knowing that finding a warrant would wipe the slate clean and render the constitutional violation
That's
irrelevant.
absolutely not true. It would wipe the slate, saying they wouldn't lose the evidence and they wouldn't have a lot to lose. They still made an unlawful stop. They violated someone's Fourth Amendment, and they would be subjected to, like any action, to a civil lawsuit if they wanted to. So what she's saying is absolutely not true.
It would cut the heart out of Terry. It would create a new form of investigation. Officers would be stopping citizens
I might agree with that.
and hunting for warrants.
In high crime areas, a bunch of people, it's like, you know what? That dude looked at me. He looks nervous. He's sweating. He's probably got a damn warrant. Let me stop him, see if he's got a warrant. Then I'll search him after the warrant. But again, that's taking into the, that's a big leap that you got a bunch of cops out there that want to go out and stir up work over some poop-up misdemeanor warrant or infraction failure to appear warrant just in order to search somebody. I mean, I don't buy it. I don't know a lot of cops that would do it, maybe in some small areas, but we'll see. I'm thinking cops that work in these high crime areas that they don't want to identify, cops that work in these areas where they have 80% of the people who live there have freaking warrants that they don't want to identify. Cops that work in those areas are normally too damn busy going call to call and answering the other violent crime, which got them 80% of the people warrants in the first freaking place, to be running around trying to stop people. But what do I know? Hell, I was only a cop for 30-something years.
It's already the practice in many communities, and if Utah's rule is adopted, it will become the norm. It's unnecessary for this Court to take such a sweeping view as Utah has.
Well, would that be true if, let's say, 0.5% of the residents of South Salt Lake or Salt Lake City have outstanding warrants?
The statistics are important to our argument, but not necessary, because even without the statistics, we know that officers make stops precisely for that reason.
How do we know that?
The warrant. That's why
Does she have cases? Of course not. She's just making that shit up.
They can target communities. And so even if there's just a very minor amount of warrants, they can still target communities.
If you live in
that
a
may
community
have a
where
greater
80% of the people
incidence
have warrants, maybe that community needs targeting. Rick, you can't say that. That's whatever.
And if this were the rule, there would be no downside. Officers.
Well, it's true there's a downside. If the officer makes an illegal stop,
Amen.
the officer exposes himself or herself to all sorts of consequences. But you're saying that if the on the statistic that I gave you, if there's a 1 in 200 chance that there's going to be an outstanding warrant, so the officer says, well, I have no reason to stop this person, but if I stop 200 people today illegally, then I'm going to find one who has an outstanding warrant. You would say that gives the officer the incentive to make those 199 illegal stops?
Well, it's still precisely why the officer would be doing it. He's running the warrant check. In this facts situation, we're talking about a very narrow set of facts where we have an officer that detains someone, and as part of that detention,
a warrant check without
there is
detaining
a warrants
you.
check.
The issue is, was the stop lawful or not? And they're saying it was a close call. I think it sounds pretty reasonable, but you know what? Courts always can outrule what a cop thinks. So you move on. Do you really need to change everything because of one case where you got 4 different courts that can't agree? So you bring it up to the 8 dummies or 9 dummies that they won't agree either?
These were not separate things. It was inherent in this stop. And so yes, if an officer is detaining someone under those circumstances and runs a warrants check, he's doing it precisely.
Could you is it permissible to do a warrant check as part of a lawful Terry stop?
A lawful Terry stop?
Yes.
In our brief, we've referred to Rodriguez, and this Court has certainly said that, at least in the context of automobile stops, yes.
Well, in this case, the State, as I understand it, please correct me if I'm wrong, has conceded that the stop was unlawful. It is not conceded that it was flagrantly unlawful. Isn't that correct?
Well, that's right. That's right. And so, the position that the State has taken is.
So we take the case as one in which there was no flagrant conduct?
So the test under Brown for flagrancy really has two elements. One is whether it was done deliberately or purposefully. And we know from Dunaway and Taylor and Brown itself that unlawful conduct that is undertaken with the purpose or with the hope of finding something, with the hope that something turns up, is deliberate and is flagrant. And Dunaway tells us that we don't need some overarching flagrancy, that that's enough. And so the purpose is important. It's viewed from an objective standpoint. Here we have an officer that told us his purpose, but objectively we do look at purpose. We look at justification. That's how we know the limits of a Terry stop.
What's the number? What percentage of people have to have warrants before you can imply that whenever an officer stops someone, it is to, illegally search them because they're very likely to have an arrest warrant?
Well, I think that the proper focus, I don't think breaking it down to numbers is the way to go. I think the proper focus is on deterrence. And we know deterrence is not just.
Well, I suppose that's related. Your brief had a lot of numbers in it. And if only 1 out of 100 people have arrest warrants, then I think you really couldn't imply that that was the purpose of the stop. And some of these numbers, obviously you have in particular communities high numbers, but
Rick,
some of them
stop asking those questions. All right.
Like me, I was surprised how low they were. 323,000 is a big number, but that's the entire state of Florida.
So the officers run warrants warrants checks because they're likely to turn up warrants. When they target certain.
Why is that? You mean every time a police officer pulls somebody over and runs a warrant check, it's because he thinks it's likely there's a warrant? Might it be to protect him when he walks up to the car? He'd like to know
brother.
that the person is wanted for murder.
He sounds like he might actually have a brain cell up there.
Right?
So running the warrants check tells him that. That's when you run the warrants check, you're looking for a warrant. In this case, that's what Officer Frackbrell was doing. He wanted to try to find out something about Mr. Strieff, and so he ran the warrant.
Mr. Strieff, if he ran him and he had a warrant for drugs and sales of methamphetamines, and then he found methamphetamines on him, all of that could be used for a warrant to search the house. But you don't have suppression issues when you're trying for a warrant, because that gets in a different area. I can use stuff that I know, and I don't have to justify where I got it necessarily in order to put it in a warrant. All I have to say is, I know this, and knowing this makes me believe I'll find evidence in this house.
Let's check. These kinds of stops, it is.
But I guess, you do require us to determine whether or not he ran the warrant check to ensure his safety in this interaction, or as an investigative matter. Does that make a difference?
It makes a difference in the sense that when there is a stop that is made, that the warrants check is inherent in that stop. So I guess my answer is no, it doesn't make a difference, because when the warrants check is inherent.
Why wouldn't it? Now, look at our case, Rodriguez case. We assumed that the
it's
check
not only
there
for the
was to
safety of
ensure
the
the
officer, you
safety
bunch
of the
of freaking morons. It's also that if I don't run him for a warrants check and I write him a freaking ticket because he stubbed his toe and left a mark on the sidewalk and somehow some jurisdiction made that a finable offense, and I write him a freaking ticket like the CHP and let him go without running him, and next thing I know he was wanted for murder and he kills 4 other people, everybody's going to be telling me, you big freaking idiot, you had him in custody for the freaking gum on the sidewalk ticket, and you didn't even run him, and now he killed 4 people. It's your fault. Maybe that's why we run him. Freaking idiots.
Officer.
That's right.
All right?
Right.
If the stop here is purely investigatory, isn't that different? Can you have an investigatory stop based on no suspicion? You were right when you said he stopped to check for the warrant. The question is,
that is not why he stopped him.
Kennedy's
I guarantee you, in this officer's mind, he stopped him to question him about what he's doing in that house. And if he has prior drug charge, if he's on parole or probation. You're in a high crime area. We had a report that they're selling drugs. You came in and out of that house from where they're selling drugs. Either you live there or you don't. I'm furthering my investigation and I'm collecting more information. Now, whether or not I can ID you and see if you have a warrant, well, maybe that might be iffy. I'd have to know more facts.
which is that legitimate?
Can you have an investigative stop to check for a warrant without reasonable suspicion or with?
Without.
Without, you cannot. You cannot, the officer cannot detain someone without
They're correct.
reasonable
I can't
suspicion
detain them
to
without
run a
reasonable suspicion to run a warrant, but I can run a warrant without reasonable suspicion. I just told you several cases. I can see you walking down the street and know I arrested you 4 times. Like, you know what? He's always got a freaking warrant. He never shows up to court. And I did this freaking 5 times a month. You know, dude walking by, I'm like, shit. That's Billy Joe Bob. He's always got a warrant. He's good for a warrant. I ain't doing nothing. Hell, I'll hook him up. He's got a warrant. Get on the radio. Hey, run Billy Joe Bob. I've arrested him 4 times. I think he's about 25 years old. Oh yeah, he's got a warrant. Failure to appear for freaking possession of crank. Okay, thanks. Show me out with that subject on so-and-so. And I walk over there, I go, dude, you got a freaking warrant. And I search him, and then I decide on whether or not I'm going to arrest him and take him in, or maybe he can give me information that's better. And that's what I usually did is, hey, dude, if you can tell me where I can find a gun or a bigger crime than your freaking meth warrant, which I don't give a shit about, I'll let you go. And then I get information. And that would be legal. And I may use that information to get a warrant on a child molester or something.
Let's check.
As I understand your position, you don't argue that the arrest was unlawful. Is that right?
Of course.
We don't. We have never challenged.
So the arrest was lawful, and when the officer is making the arrest, it's permissible for safety purposes for the officer to frisk the person who's being arrested. Do you agree with that?
Yes.
It's not a frisk.
So it's
if I'm arresting
so it's a
you.
lawful
It's
search.
a search.
Correct?
We've never challenged the search.
Isn't it? Can you give me one other example of a situation in which this court has held that the fruit of a lawful search must be suppressed?
I don't have another case in this precise circumstance. Our position throughout.
Well, in any circumstance.
So this case has not come before the court. We know that an arrest warrant is not always an intervening circumstance. It wasn't one in Taylor versus Alabama. Even Utah and the Solicitor General don't take the position that just the arrest and the search incident to arrest are enough, because they've conceded that dragnets, that any evidence that's found in a dragnet is a fruit. And so that's.
I'm just pointing it out that that's a curiosity, isn't it? To have a law, to suppress the fruit of a lawful search, and maybe you need strong circumstances to justify such an unusual and unprecedented result.
Well, our position is these are strong circumstances because part of deterrence, the value of deterrence is found in the strength of the incentive to violate the Constitution.
What
you want to put an incentive out there not to violate the Constitution? Cops start going to prison when they violate it and they lose their jobs. That's your incentive. This Mickey Mouse arguing over whether or not to let guilty people go who have warrants and who are carrying guns and who are committing crimes we should let them go because we want to hold officers accountable. But we don't want to put officers in prison, and we don't want to force them to lose their job if they get charged for violating the Fourth Amendment. Why don't we have a law for cops violating the Fourth Amendment? Well, Rick, you can't ask that. Our legislators are busy figuring out what freaking bathroom they want to use.
He said you don't question at all the arrest, and you don't question, once there is an arrest, the pat down
My question
for
is your
drugs.
ability to be on the court and have a coherent sentence.
The pat down for guns. But are you saying that the arrest for the warrant is a totally different crime doesn't permit you to search for evidence? It only permits the officer to protect himself
out of control.
by patting
you
down for
do not pat
weapons?
down after you arrest. You search. You're putting a guy in your car, you're transporting him to jail. You don't do frisk, and you don't do pat downs. These people don't even have the terminology or understand what they're asking. Much less they don't have anybody with comp experience there explaining it. They got a bunch of freaking lawyers who want to use big words and sound like they know what the hell they're talking about. And they got no actual experience on the road.
Well, our position is that anything that's found is the fruit of that illegal detention, not of the arrest, because the arrest and ultimate and subsequent search are a fruit, but they're not suppressible. They're not something that we have fought against because, again, we have the warrant and authorization.
But if the individual is going to be arrested and put in jail, isn't it standard procedure and lawful procedure for the authorities to search that person thoroughly? They couldn't have the person bring drugs into the jail or things that the person might use to hurt himself or other people.
It would still be a fruit.
So it would. Well, what does that mean? But it's not.
What she's talking about is a fruit. She's saying, had not for the illegal stop, they wouldn't have found any of that. So therefore, it's fruits of the poisonous tree. And I kind of agree with her, but again, you have to look at it reasonably. Do we want to start letting people go who have crimes and who are going to hurt people with weapons and suppress all that on an officer who, what I think, had reasonable suspicion, and other courts thought he had reasonable suspicion and they upheld his position. But then some courts said he didn't have it. And so now we want to make a rule. Oh.
Conduct on their part, right?
Right.
Okay. But so you're asking for the suppression of the fruit of a lawful search.
What we're asking for is the suppression based on the unlawful detention that began the encounter.
Notice how they're not saying we should just let the guy who was arrested get away? Because a judge has already signed a warrant to arrest them, and he's reviewed probable cause, and he said arrest this person. And since government protects government, they don't want to say, you know what? Because he unlawfully found him, he shouldn't even be able to arrest him. He should just let him go. Notice they're not asking that. They only want the evidence that was found after the lawful arrest from the warrant suppressed because of the unlawful detention.
Begins with the stop. The stop itself.
Well, I said unlawful detention. She just said unlawful.
Is unlawful.
It wasn't unlawful. I think it was lawful. A couple of courts thought it was lawful, and a couple of courts didn't. But everybody's talking like it's already been decided it was wrong.
The state has conceded that throughout. So what's the problem with that stop? This is a stop, the kind of stop that that officers are faced with every day. It's a basic kind of stop. What do we know about Terry stops? The officers have to have a reasonable articulable suspicion. Cortez tells us that it's really a two-step assessment. They have to, number one, look at the totality of the circumstances, and number two, they then have to look at whether there's an individualized suspicion. Does this tie in with this defendant? So in this case, what does the officer know? All he knows is that there's some short, not terribly frequent, short-stay traffic at the house.
That's not all he knows.
Sees my client
She left
emerge
out the
from
part
the
that the neighbor and the tipster called in and alerted law enforcement and asked for their help because the house had a high volume of traffic and short-stay traffic. She just suddenly left that out. That's all the officer know. Did y'all catch that? How she just kind of omitted that fact? Because a lie is omission of the truth. But nobody wants to say that either.
house knows nothing else. So even under the totality, a reasonably well-trained officer
I totally disagree.
should have known this stop.
I'm a well-trained officer.
Not.
I think it was absolutely fine.
Was bad.
You're arguing something that the state's conceded, right?
Well, I think it's important because the state has taken the position that this was just a factor too shy of what was needed. And being a factor too shy of Terry leaves us with nothing. Terry is already a fairly low standard.
But you still have to say that it's flagrant.
Well, my position is twofold. One, that flagrancy has two aspects. One aspect is just the deliberate aspect, and that in this type of a stop where it's made for the purpose of running the warrants check, the warrants check is inherent in the stop, that's enough. But secondly, if we were going to include a different
I've
definition,
never stopped
it would be that
anybody
it was blatantly
for
unconstitutional.
just the purpose of running a warrant check. If I stop them, I want to get their name. I want to identify that I contacted them. I want to gather information on either where they're coming from or where they're going or what they're up to or why they're in the area or why they look like the person I'm looking for or why they have contact or why the person that I'm chasing is friends. I contact people for a lot of reasons. I've never said, you know what, I'm going to stop this person and run them just for warrants. Shit. I might as well throw, whatever. That's freaking crazy.
Constitutional. And so that's why I'm moving into the stop to talk about what was the problem with this stop, what do we expect of our police officers, what do we need from our police officers.
You said that the stop was made for the purpose of running for the arrest warrants. I just don't know the basis for that, other than your statistics that in certain areas there are a high number of arrest warrants. In many areas there aren't. I mean, is it entirely empirical? Do we have to accept and generalize from your empirical evidence that the purpose must be to execute or to check for arrest warrants?
No, because we know that that's precisely what was done in this case, what is done in some other cases. In this case, we have an officer that makes a stop.
All officers
and
do that.
Immediately runs
Once
that
we get your
warrants
name,
check.
we're going to have them do the stop because we need it to come back before we let you go or before we have information or before the incident goes to shit. What? Well, you think you think it's smart that maybe we should run a check after we let him go? Maybe the next morning when we get in, we're having our coffee and donuts. Maybe that's when we should warrant. And then we find out he's wanted for a mass murder and he's out to kill his ex-wife and he's got freaking 14 restraining orders. Then maybe we should run it the next morning. And then we find out he killed his wife and it'll be like, you cops aren't protecting women. You should have ran him more quickly. That was not due diligence running him so late. Sometimes it's just a no-win and now they're just making shit up.
But he immediately runs the arrest warrants check when he makes the stop because he wants to know who he's dealing with. It'd be, I think, bad police work to not run the warrant check until after you've had an interaction with the person when the danger that you could have found out about might have been when it's too late to act on it.
The way he finds out who he's dealing with is if there's a warrant. The point is he didn't have a reasonable suspicion.
And he observed the place and he saw people coming in and out and your client left the place. That sounds suspicious to me. And it's reasonable to me.
And so
no, I understand that, but you're implying, I'm still trying to get at how you decide what the purpose was. In your brief, you say several times, the purpose is to run the warrants check. And I just want to know why that's the case.
Because it was immediate, it was inherent in what he did, because he stated that his purpose in stopping my client was to find out about my house, find out about the house.
If the cop said he stopped him to find out about the house, he didn't stop him just to run a warrant.
Normal for him to run a warrants check and normal for him to want to know who he's dealing with. So
we now have that's saying that the warrant check is something he does when he arrests people. I don't doubt that. But it doesn't prove that that was his purpose in the stop.
So the intended consequence of running a warrants check is to find a warrant, number one. And number two, our statistics show that in a sizable number, officers are likely to find warrants. The other concern is if
you're asking us to say that as a matter of law, you want us to hold that the purpose of this stop was to run the warrants check? I thought the purpose of the stop was to find out what was going on in the house.
I think that when an officer...
The record just doesn't support the first proposition that I made.
When an officer detains someone as part of a fishing expedition in the hope that something will turn up.
This officer stopped in order to get information to further his investigation on what was going on with the house.
Is a problem.
There was no suspicion here. Your client wasn't frisked.
I'm sorry, wasn't frisked?
No. There was no activity that the officer is alleged to have seen that would put the officer in fear of any that this gentleman was violent or was going to turn on him or do anything else.
Of dealing with drug members, they usually carry guns to protect their drugs so they don't get ripped off. How the hell can she say he had no reason to be suspicious of a guy leaving a suspected house where they're selling drugs? Are you kidding me?
No.
Correct?
Correct.
So the purpose, as I understand what you're trying to say, is he is now routinely checking every single person that he stops, whether with or without reasonable suspicion. There can't be any other reason other than he wants to find a warrant or not. But so part of the stop may be to investigate, but the other part of the stop is he's doing this routinely with no reasonable suspicion, with no articulable fear for his own safety.
Why does
he's demanding people's names and he's running a warrant?
A building with metal detectors and armed security guards. They have no reasonable, articulable suspicion that they're in any type of danger. They don't have any threats. Why do they need metal detectors and guns at the Supreme Court? That's how stupid she sounds.
To do what? You're saying to find the warrant.
Find the warrant.
Exactly.
How often are people stop driving and an officer walks up to the car and they're shot? Does that happen a fair amount of time?
It does happen.
It does happen. So is there no other reason for checking to see if there are warrants out for that person before you walk up to the car or before you conduct an inquiry with the ticket? It seems to me not wanting to get shot is a pretty good reason.
But this presents a completely different scenario. This officer approached Mr. Strieff. He knew very little about him. As a matter of deterrence, a reasonably well-trained officer should have known that there wasn't enough there because he didn't know anything about my client. There was no individualized.
99% of the people I stop, I don't know anything about them. That's why I'm stopping them.
Suspicion.
Well, we really don't know very much about exactly what happened here, which is unfortunate. But what the officer testified was that he didn't just grab this guy and say, "Give me ID," and then run a warrants check. He did say that he approached him and he said he identified himself. He said he thought there might be drug activity going on in the house, and he asked him to tell. He said, "I asked him to tell me what he was doing there." Now, we don't even know what unless it's someplace else in this record, we don't even know what your client said. But he could have said, What am I doing there? Yeah, I live there, or my mother lives there, or my best friend lives there. But whatever, we don't know what he said. But then at some later point, he ran a warrants check. So how can we infer from that the whole point of the stop was to run the warrants check?
So a really important part of the officer's testimony was that he didn't remember what that answer was. So if my client had said, I went in there because there's someone who's ill, and I've been visiting for 20 minutes, or this is where my friend lives, that's why I was there. End of inquiry. And the warrants check shouldn't have been run. A reasonably well-trained
Maybe
officer
the officer didn't
should
articulate
know.
other things
The
he saw,
important part of
like
this,
the guy sweating and looking and dodging and appearing to be hiding a gun in his waistband, and there was a bulge. Maybe the officer just didn't articulate what he was doing, and that's why you can sit here and go ahead and automatically know what he was doing.
this case is that if we're only looking at, we're not just looking at deterring Officer Fackrell, we're looking at deterring future conduct by officers. And the Terry limitation is something we want our officers to know. It's fairly straightforward. This is a fairly straightforward case that is going on every day in this country, where officers are looking at houses, watching houses that maybe might have drug trafficking going on. They're trying to establish probable cause. Case law is relatively clear about what you need to get probable cause on a house. It's also relatively clear about what you need to get individualized suspicion. We know from Cortez we need those two elements. We also know from Ibarra that just being in proximity to other people is not enough. Being around, even when the officers have probable cause to search or probable cause to arrest someone, if you're standing right there, it's not enough. So it should be clear to an officer that my client leaving a house that he doesn't even have probable cause on, that he's trying to find something out about.
Well, all he did was go from the house to a convenience store, not in a car, but walking.
Right.
He walks to a convenience store. He stopped in the parking garage, but without a car. And I go back to, this is not coming up to a parked automobile and getting shot, correct?
Right, right.
Would your rule apply in that situation?
Well, when an officer makes a stop of
Would your rule apply in a situation where the officer approaches the car for a purpose that is later found to be insufficient under Terry? You would suppress whatever evidence is found in that situation too, right?
If the officer did not have a reasonable suspicion for the stop.
Okay. So it would apply in the stopping of the automobile situation.
It would, but
okay.
But again, in these cases, if there is a warrant, we haven't argued about the warrant itself. What we've argued, our concern is the random stops. And our concern is not just from.
He watched it. He observed activity that was consistent with the tip. He observed activity that was within his training and experience.
My client. It's for all of those innocent citizens that are walking
innocent
around,
citizens
that
with
are
arrest
stopped,
warrants.
that
Yeah, okay.
Warrants check is run, and nothing comes up, and then they're sent on their way. There's no oversight. The officer is encouraged to engage in a catch and release type of approach with our citizenry, and Utah's rule would be something that would create that incentive.
In your brief, you took the position that an event is intervening only if it is unforeseeable.
Well, our position is that an intervening circumstance needs to be independent, and it needs to be a break in the causal chain, and that when a warrant is run, and it needs to be something that is not directly related to the officer's conduct. And so, because the warrants check is an inherent part of the detention, it's not an intervening circumstance. And that's something that the Utah Supreme Court unanimously agreed with, and the dissent in the Utah Court of Appeals as well, agreed
What
that
that
this
means
is a
is the
natural
appeals
and
court did not agree.
foreseeable consequence.
Did you catch that, how she slid that in? Oh, yeah, the U.S. Supreme Court unanimously agreed. Oh, with the dissent of the Utah Court in the Appeals. So that means Utah Court of Appeals did not agree.
It is the intended result. It is not something that is independent, that comes as a surprise. And that's really consistent with this Court's case law in dealing with intervening circumstances. Spontaneous confessions are something that are independent. They break the chain. We look at free will, and that's independent and breaks the chain. Witness testimony. But here, there was no break. It was a direct result of the officer's conduct. The rule that we are really asking the Court to adopt follows settled exclusionary rule case law, and that is that if there is the bad stop, it's suppressed unless there is attenuation. And, of course, if there hadn't been a warrant, if the officer had just stopped my client and searched him, I don't think anyone's contesting that would just simply be suppressed.
If a frog had wings, he wouldn't bump his ass when he jumped. Your client did have a freaking warrant, and therefore he was searched incident to arrest of the warrant, and that's how it was found. So it was a legal search. Now, I'm not disagreeing with her that, look, if we're going to have an exclusionary rule, then just make it a rule. If you get evidence and you start off bad, you lose it. That's one way to let bad people go. The other way is when cops do something wrong, they're charged, they're held accountable, they lose their job, and they go to prison, and they get fired. Nobody wants to say that's a fix. I don't get it. Why? Because government protects government, and these flunkies want government protecting them.
Attenuation. And in this case, there was no attenuation as well, because all three of the factors that this Court has looked at work in favor of suppression. The temporal proximity works with us, obviously. It was contemporaneous. It was immediate. It was inherent. It's not an intervening circumstance because it's not independent, and it's not a break in the causal chain. And it was deliberate conduct on this officer's part.
Well, again, she keeps making all these accusations blatantly unconstitutional. Everyone else said it was a close call. You had 3 or 4 different courts that couldn't agree whether it was right or wrong, or was a close call, or was blatant. So, but she suddenly, oh, no, it's blatant. Typical liberals.
You disagree with Judge Friendly's analysis in the Friedland case?
In what respect?
Well, with his analysis, because as I understand, it took the position opposite to what you're arguing, and I just want to know if you have a basis for distinguishing that precedent.
I guess I don't. No. So our position is that this falls squarely within the Court's settled case law. We're asking that the Utah Supreme Court be upheld. And
you agree that attenuation is based on deterrence, that the attenuation determination is based on a calculation of the deterrent effect of the ruling?
I do. I agree that the focus is on deterrence, and I think that in this circumstance, there's powerful deterrence to adopt our position and to not follow Utah's position. If Utah's position is adopted, part of deterrence is looking at the incentive to violate the Constitution.
Okay, who thinks it's
and
an
looking
incentive
forward
not to violate the
to
Constitution
see
if you can be charged and go to jail? Raise your hand. All right. All you dummies with your hand down, you don't get it.
What would happen with the rule. And under Utah's rule, there would be nothing to stop police officers from stopping people on the street, articulating something. Terry doesn't take much. Most officers can articulate some sort of justification, looking for the warrant and then sending people on their way. So we believe that deterrence would be very well served by adopting our rule.
And your deterrence argument doesn't depend at all on statistics.
Even without the statistics, our deterrence argument works, because the point is, a reasonably well-trained officer
you don't even got officers out
should
there
know
that understand what the hell Terry
parameters of
is,
Terry are.
much less what case law is, much less what they can and can't do, because the courts keep changing it, and it doesn't matter what the law is anyway, because you get a left-wing judge that don't agree with it, and he'll overturn it, throw it out, charge you, and change the law. So the law is not the law, and when it doesn't apply to everybody, it shouldn't apply to anybody.
This officer did not.
So if 1 in 1,000 people has an outstanding warrant, that's enough. That statistic wouldn't upset your argument.
It wouldn't upset my argument, because officers run warrants checks because they're likely to find
1 in 10,000. Would that upset your argument?
I suppose.
I got to get to a number where you're going to say.
In those communities, then you're going to see much less of this behavior. Much less of the running the warrants check.
So she just said that if you're in a community where 80% of the people have warrants, you're going to see more cops running people for warrants. And if you're in a community where 1 in 10,000 has a warrant, then you're not going to see cops running warrants. Well, that's just crazy talk, isn't it? Who thinks that's common sense? It's actually the bizarro liberal world of the opposite of common sense.
In order to find a warrant, it's going to self-correct. But for the most part, and the flip side is there's then no reason not to run them if that's the rule. But for the most part, in most communities, the incentive there. The other thing is, with Utah's rule, it could create an incentive to have even more warrants for even more minor infractions. This was a traffic matter. Many of these warrants in the cases down below are minor traffic matters.
What was it? We know. Was it a ticket? Do we know?
It's not in the record.
It's not in the record.
Yeah. But it was referred to as a minor
Do
traffic
you think the
matter.
judges in the traffic courts are going to start issuing lots of warrants because they want to provide a basis for
like a judge is going to sit there and,
randomly
you know
stopping
what?
people?
I'll just issue out a bunch of warrants so I can help the cops go out and violate people's rights and just run everybody to see if they have a warrant. That's what this idiot believes.
The point is only that it creates an incentive to not be as careful. It creates
I'm very surprised that Justice Alito doesn't know that most of these warrants are automatic.
Ooh,
you don't pay your fine within a certain amount of days.
Wow. She just dogged. That was a serious dog.
They're issued virtually automatically.
Right, and that's exactly what this one was.
So it doesn't create an incentive of the kind you were arguing you were worried about before.
I'm sorry.
The warrants are automatic. You were suggesting that, one thing that will happen is they'll be issuing all these warrants if they know they can get evidence from illegal stops. And because the warrants are automatic, they're not going to be issuing all these warrants, are they?
They're automatic in certain circumstances, and those circumstances would increase. So they're automatic right now for no insurance or for speeding. They would increase, and they'd be automatic for infractions. And the other aspect is the databases and the incentive to keep those databases accurate and up to date. It's our position that this absolutely plays into a deterrence, and that
so
Utah's rule would have
justifications. And I mean, I kind of agree with her point that they shouldn't be able to do it, but they've ruled, and you can. And I don't think out of the DUI checkpoints, but they ruled on that. And I don't think a dog ought to be able to come by on a traffic stop and start searching and detain people, but they ruled on that too. So the courts are always ruling where people disagree.
overwhelming impact that would create a powerful incentive for police officers to walk up to people on the street and simply stop them. We're asking, unless there's further questions, that the court affirm the Utah Supreme Court. Thank you.
Thank you, Ms. Watt.
4 minutes left.
Mr. Green, you have 4 minutes remaining.
Thank you, Mr. Chief Justice. If I could just make three brief points in response. First, to the suggestion that officers make random stops in order to find a warrant to conduct searches of this type. There's actually no evidence of in this record that that's what happened here or that it happens more broadly. In fact, I think the opposite is true. If you look at page...
Seeing practice to run warrant checks. Every stop, legal or illegal, he says he runs warrants. It's on the street or in a car. Meaning that's what the police officer testified to.
He runs them, Justice Sotomayor, for the purposes I think that have been discussed today for safety rationales and other reasons, but there's no actual evidence that he runs.
So we now have a new rule. We've taken running warrants for traffic stops that we've thought were legitimate because they had to do with highway safety. Now we're saying to police officers, run warrants on any name you get, because all you have to do is wave the flag of safety.
No, Your Honor, that's not what we're saying. We're saying that there's a safety rationale for the warrant check, but beyond that, there's also the important flagrancy safety valve that we talked about here. And with respect to this particular warrant check, on page 101 of the appendix to our petition, there is actually a finding from the district court that the reason that this officer stopped this particular defendant was on suspicion of drug possession or distribution. It wasn't for something else. So that finding is here. And more broadly, this rule, as we've noted in our papers, is in fact the majority rule among the courts that have addressed this issue throughout the country. In the United States, in the Seventh Circuit, the case of United States versus Green was decided in 1997, almost 20 years ago, and that, of course, involves states with a large number of metropolitan areas, Chicago, Milwaukee,
that are
and
dangerous
Indianapolis.
And have 80% people having warrants. Imagine that.
And there's no evidence in this record or before this court that these sort of random stops in order to check for warrants is happening in those jurisdictions. So we think the actual practice and the way it bears out and has borne out in areas where this has been adopted undermines that particular argument. And second, Your Honor, with respect to the question of whether a subjective purpose should come in, responding to Justice Kennedy's question to this inquiry, I think if this court were to do that, it would become an outlier of sorts in the case in this court's Fourth Amendment jurisprudence. And I think with respect, if it remains an objective inquiry and consistent with the rest of this court's cases, that objective inquiry will capture the flagrant cases. We've cited 4 cases from 4 different state courts in our reply brief, in footnote 1 of our reply brief. That's Illinois, Missouri, New Jersey, and Oregon, where the courts that have applied this rule have undertaken the flagrancy inquiry and have in fact suppressed evidence because the initial stop was flagrant. Finally, a third point. As we've noted in our briefs, Your Honor, the respondent here has abandoned the Utah Supreme Court's rule that an intervening circumstance must in fact be something attributable to the defendant's own free will. We think that's appropriate based on that concession that this court should reverse the judgment of the Utah Supreme Court, and leaves to the question, of course, of what rule to adopt instead. And we think, Your Honor, this intervening circumstance here, this arrest on a pre-existing warrant that arises from probable cause based on facts completely unrelated to the circumstances and the facts of this stop, is exactly like what happened in Johnson versus Louisiana, which is the case that this court pointed to in Brown versus Illinois, where it adopted and said the intervening circumstance is critical to the attenuation inquiry. It's a straightforward application of that particular test. There are no further questions.
And what did they rule?
Thank you, counsel.
Shocker.
Case is submitted.
The ones that are highlighted voted for it, and the 3 that were obstructing the attorneys from making their case voted against it. Okay. In the absence of flagrant police misconduct, meaning if there's flagrant, then this doesn't apply. The discovery of a valid pre-existing untainted arrest warrant, and when they go untainted, they're talking about an arrest warrant that maybe wasn't made on false probable cause or lying or something. weaken the connection between the unconstitutional investigative stop and the evidence seized on the incident of the lawful arrest, which allowed the evidence to be used against the defendant. Justice Clarence Thomas delivered opinion of 5-3 majority. The court held that the evidence obtained in violation of the Fourth Amendment protection should not be excluded from evidence when the cost of exclusion outweighs the benefits. I'm not sure what that means. Maybe the seriousness of the case. Exclusion is not justified when the link between unconstitutional conduct and discovered evidence is too attenuated. To determine whether the connection is attenuated, courts must examine the temporal proximity of the discovery of the evidence to the unconstitutional conduct, the presence of intervening circumstances, the flagrancy of the police misconduct. Based on the announced factors, when a valid warrant is discovered after an unconstitutional investigative stop, the connection between the unconstitutional conduct and the discovery of evidence to a lawful arrest based on the warrant is sufficient attenuated. Justice Sotomayor wrote her dissent. Let's see who she blames. In which she ordered the Fourth Amendment exclusion rule was intended to prevent officers from taking advantage of their own unconstitutional conduct. I agree. Which is the case here. Because the initial unconstitutional stop was clearly calculated, it was not clearly calculated, you freaking liar, to produce further evidence. BS. It was not an intervening circumstance. Justice Sotomayor also argued that allowing police to such free reign essentially created a... You notice that other attorney kind of agreed with her dissenting opinion, which is why I said I thought he was left-winging. Second-class citizens should be subjected to police invasion of rights at a whim. Justice Ginsburg woke up, wiped the oatmeal from her face, and joined in the last portion of the dissent. In the separate dissent, Kagan wrote, the discovery of evidence was too closely connected to the unconstitutional investigative stop for a valid warrant to attenuate the connection. Because the two events were closely connected in time, the warrant itself was not an intervening circumstance, and the police conduct was purposeful and flagrant. Oh my goodness. The exclusionary rule should apply in cases like this one. Oh, Justice Ginsburg woke up again and joined in the dissent. All right. Well, in that there, you can argue it out or go tell the other guy that I was being mean to him or whatever. That's my stance. I kind of think it ought to go away, but I understand why they didn't want to make it a flat, clear rule. It still goes away if you can find flagrant attitude from the officer. So there's still a check, but government just keeps raising the bill, and they've been stomping on the Fourth Amendment for I don't know how long. So to me, this isn't that big of a step from, DUI checkpoints and dogs and, all the exception for vehicles and all the other stuff, no-knock warrants and all this other crap. But anyway... Argue that in comments. Well, not there. Wow, it was long. 151.